What's up, guys? Hey, it's Clint Coons here, and in this video we're going to talk about 4 mistakes that I see residential real estate investors make with their rental limited liability company. All right, so here's the deal. Whenever you have a property inside of a limited liability company, the first mistake that I see people make is they want to contact the lender because that property has a mortgage on it. Originally, when you bought the property, you owned it in your own name. Now you've deeded it into the limited liability company. You think, hey, I should call Wells Fargo and let them know now that that property is held by an LLC. Mistake number 1, do not contact your lender. There's no need to do that. Pay your your mortgage out of the limited liability company. There's no problem with that. They're not going to question you. And I know if you've watched my other videos where I talk about Freddie, Fannie conforming notes that you can transfer real estate into a limited liability company and the lender won't accelerate your mortgage. But the problem here is if you call them and let them know, they're not going to be looking to accelerate your mortgage. They may want to hit you with a mortgage transfer fee, which could be anywhere between 1 to 1.5% of your outstanding mortgage balance. So there's no reason to contact your lender to let them know that your property is now held by a limited liability company. So that brings me to the second mistake that I see investors make with LLCs. Putting their property into an LLC. They use a quit claim deed. Now, if you watch some of my older videos, I've discussed using the proper deed form. You don't want to use a quit claim deed despite what your friends may tell you, because that type of deed will void your title insurance. So when you transfer your real estate in, let's assume that 3 years down the road, you discovered there was a defect in title. Now, you're going to be stuck holding that defect now, and you'll have to pay to clear title on your property, and your insurer, title insurance that originally insured that property when you bought it, they will disclaim any coverage there because you transfer title from your name into the LLC and you did it through a quit claim deed. So how do you preserve your title insurance when you go to your own entity, an LLC? You use a warranty deed. Now you're warranting that you have good title and you're giving it to your LLC. And if you're lying because there happens to be an encumbrance on it, you can always sue yourself. Now, I've told you you don't want to sue yourself because, it just seems stupid. But in this instance, if you had to do it, your title insurance company would now have to step in and indemnify you and cover that title defect because it arose prior to you originally taking title to the property. Therefore, it is covered. Using a quit claim deed will kill that off. Now, the next 2 mistakes are really about operating the LLC after the property's been transferred in. And the first one, which would be number 3, is changing the name of your limited liability company. Now, just the other day, I was talking to a client and they'd set up a limited liability company. They get this LLC set up here and they called it, let's say, Ross LLC, because they thought they're going to buy a property on Ross Street. Well, it turns out they didn't buy a property on Ross Street. They bought one on Evergreen. So they have this property now inside of Ross LLC, but the address here is 1314 Evergreen. They're thinking, you know what? I just don't know that the Evergreen property is in this LLC because it says Ross. So what we're going to do is we're going to change the name to Evergreen just by amending the Articles of Organization with the Secretary of State. Simple, right? Well, although it's simple, it can screw things up for you down the road, because when you change this limited liability company from Ross to Evergreen, when you go to sell the property, title's going to look, and they're going to see that this property was held by a company named Ross LLC. Now, Ross is no longer in existence. It's Evergreen because you changed the name. So that can create a problem for you when you sell. Not to mention if they write a check or they want to transfer proceeds from the sale out of escrow to Ross, Ross is no longer in existence. It's now Evergreen. So changing the name of a limited liability company can be problematic. It can cloud your title, create problems if you want to sell or refi the property. The only way you could fix that is if you also change your deed. So if you change the name on the LLC, also change the deed. All right, the fourth mistake that I see people make is when they want to move property from one LLC to another. So going back to this diagram again, let's assume that you originally set up an LLC with 2 properties inside of it. Now, you need to move this property out because you watch one of my videos and you hear me talking about having 1 property per limited liability company, and you want to set up a second LLC over here. We'll call this one LLC number 2. And you want to move this property over to LLC number 2. So what you do is a little do-it-yourself legal, and all you do is you deed the property right over. You record the deed, not a problem. Property goes into the LLC. Well, what are some of the issues that can come up when you transfer the property directly out of here over to this LLC? Well, it may be that it triggers a reassessment on that on the property tax. Let's say if you live in California, or there could be transfer taxes there because the property is going from one business entity to the other. Now, I know a lot of creative real estate investors will say, well, Clint, that's just stupid. Why would you ever transfer the property directly to another LLC? You got to be smart about it. What you should be doing, Clint, is setting up a land trust, right? Use one of those tools. And first off, what we'll do is we'll transfer the property into the land trust, and then we'll assign the beneficial interest over to LLC number 2. Think creative, Clint. This is a conversation I had with a client a week and a half ago. They were going to put the property in a land trust and assign the land trust over the second LLC. Now, I said, hey, that works. You could do that, but here's the problem again. When you originally transfer this property into this land trust, you may have to submit these documents to the assessor's office to ensure that that property does not get reassessed or increase or hit you with a transfer tax. Now, you move that land trust over to LLC number 2, and we're 3 years down the road and you want to refi the property, so you deed the property into the LLC, or maybe you deed it out to yourself down here. That's when it's going to throw up a red flag. And the county's going to say, well, wait a minute, what about LLC number 1 holding this land trust? When did LLC number 2 come about, or you come about and receive title of that property? That can create a whole other chain of problems for you. Now, if you did this, you've already made that mistake. It's simple enough to correct. You can move the land trust back into here and then take it out a different way. Or quite frankly, the cleanest approach is always going to be deed the property out of the LLC back to your name, non-taxable transfer most of the time, and then move the property over to that second limited liability company. So these are 4 mistakes that I've seen real estate investors make who have property in LLCs and they're trying to do something with it, not realizing that you could be hit with transfer taxes, you could cloud your title, or worse yet, your lender steps in and they want to nick you for a couple extra $1,000 just because that property is now held in an LLC and it's no longer in your name. All right, guys, hey, if you liked the video, hit the like button and be sure to subscribe to the channel if you've not already subscribed. Take care.